Okay, so we had a good deal of interest. I posted a question on Facebook about constitutional questions people have and got some feedback. One of the most popular questions, it looks like, is for the speedy trial issue. And I thought that to answer that, I would invite Professor Jeff Swartz, my friend, my newly bearded colleague, to help me out here. Professor Swartz was a judge in Florida and also teaches criminal procedure. So perfect person to ask and a better suited to answer these questions than I am. So I will start by asking a constitutional question, and then we'll get to maybe how states handle it. But obviously, speedy trial is in the Sixth Amendment, right? Did I get that one right?
Yeah, speedy trial exists as a constitutional right in the Sixth Amendment. It is also ruled by the 1974 Speedy Trial Act, which really just basically said we're going to look at what we've always determined in the past under constitutional speedies.
Right, and then we always run into this problem, right? You and I, especially, because I teach constitutional law and you teach criminal procedure, which is basically constitutional law, that so much of the Constitution is written in vague terms, right? So, I think people are kind of expecting some kind of a deadline when it comes to speedy trial, but they're not going to find that in the text of the Constitution. So as you say, there's statutes at the federal level and state level, but how generally do courts interpret the vague language in the Sixth Amendment?
Well, like everything else in the bill, which I've said in the past, it's ruled by a reasonableness issue. And what they judge by is, did the government, especially in federal courts, did the government really show that they wanted to move forward with the trial? And did the defendant show that he really wanted a speedy trial? In other words, he has to show this is what he wants by his acts, by not asking for continuances and not filing motions that delay the trial in and of itself. So they take a look at it from that point of view. A waiver of speedy trial in federal court can be implied from a number of acts that happen that the defendant causes. So they don't even know they're waiving speedies, and they're really not spelled out. The court can look at it and say, you caused the delays. I'm not going to say that the government has denied you a speedy trial. This speedy trial issue right now in federal court is tied to the right to a jury trial, also in the Sixth also in the Sixth Amendment. And that is because most districts have suspended jury trials. They don't want to bring people together in an area where they cannot socially distance. It creates extreme problems for running the trial and protecting everyone in it. So based upon COVID-19 and the other rulings, for example, the Supreme Court of the United States is now doing its hearings by video conferencing as opposed to live arguments. And they're experimenting with that, I think, this week. There's no way you can have a jury trial. You cannot distance people and have a jury trial with all the jurors in separate areas. They really need to be under the supervision of the court. So right now, speedy trial, for all intents and purposes, has been suspended in all of the federal courts. And I don't think anybody, absent something really extreme, is going to be able to argue that has been denied. In the state courts of Florida and in most state courts that have specific speedy trial statutes, those states that have closed down their courts or restricted their courts in what they can hear and how they can go about doing their business have entered orders. Like in Florida, the last one was Administrative Order AOSC 20-17, which is an extension of the speedy trial extension which had been granted in March. And they will continue to enter these orders for 3 weeks, 4 weeks at a time. So for the practitioner, the problem is you may go beyond the 170 days before you file a motion for expiration, or the 50 days for expiration under two auspices of 3.191 of the Rules of Criminal Procedure. You have to check and make sure that there were no extensions granted during that period of time. So let's say, for example, your trial is scheduled for October and they decide they're going to reset it until November, and you come in at the end of October and say, my 150 days, my 170 days have run, or my 50 days have run, and so there's a notice of expiration. That
deadlines, right, for felonies and misdemeanors, is that right?
There's misdemeanors run on a 90-day situation. I'm talking about felonies at this point, where jury trials are almost always demanded. We have two forms of it. One is the demand for speedy trial, which basically says you must bring them to trial within 50 days. And then there's a recapture period that has to be dealt with once you filed your notice of expiration. To the same extent, for felonies, it's 180 days, 170 days, and then there's a 15-day recapture period based upon when you file your motion or notice of expiration. So let's assume for the moment that your speedies are supposed to expire in October, your trial is set for September, it gets kicked over to November, you walk into court and say, it's been more than 170 days. Well, it really hasn't been, because there's been a suspension or extension of speedy trial periods, which have to be then figured into what your original 170 was. And if you file that motion, for example, in Florida, before the expiration has actually come about, the day after the last day, that's deemed to be a waiver of speedy trial, and now you've waived it in all and the kind of cases that the court can hear, and all of the time periods are being extended. For example, petitions for cert have been extended. Notices of appeal have been extended. Time for filing briefs has been extended. All of this has happened by court orders, like this one I'm holding up right now. So that's kind of the way that it works.
Okay, so if I can summarize it this way, when it comes to, and not just Florida, but most states I'm assuming are doing the same type of thing, but at the state level, you have to watch out for these administrative court orders, right, that are extending the time. And as a constitutional matter, there's no problem with those extensions as long as it's not the government trying, right, to avoid affording somebody a trial. Is that right?
And the defendant still always has to say, I'm ready to go to trial, I'm ready to go to trial, I'm ready to go to trial. I really want to move forward. And so as a result of which, that's the way that the federal courts look at their Speedy Trial Act. Now, some of the other periods of time that are within the rules, especially first appearance hearings in federal court, first appearance hearings in Florida, because there's been no waiver or there has been no suspension of habeas corpus, they have to go forward with those. They don't have a choice, because those are where their bonds are set. Those are where they get their attorneys appointed, all of those things. And you really can't, really based upon the Rothbury case, you absolutely cannot deny anybody those type of hearings. So those things have to be done. But in arraignments and filing of charges, those have not been extended. So state attorneys are still holding by video conferencing, but they're still holding their pretrial conferences and filing their charges within the timeframes that are designated in the rules of criminal procedure.
One more question before we run up against the clock here. But just for the lay people who are watching this, and I think most people are, when does the clock start running? As you say, it's 170 for felonies and 90 for misdemeanors. That's in Florida. When does the clock start running on that time frame?
It starts running when you are arrested, if you are arrested on the street, or when you have actually been arrested based upon a warrant. From your arrest date on in Florida is when speedy trial starts to run. In federal court, it's upon the filing of a complaint. Just being taken into custody is not sufficient, because they have to file a complaint within 24 hours. So the bottom line is that it runs from the date that the complaint is filed and you are taken in for your first appearance. And that's when speedy trial starts to run.
Okay. So actually, I said that was my last question. I lied. There's one more I have. Let's, because anybody watching this, Professor Swartz and I are we're not capable of a 15-minute conversation. But anyway, the bottom line here is, right, the right to a speedy trial is going to go away as long as this pandemic is viewed as an emergency situation.
That is probably accurate. Until such time as the government decides or the courts decide, based upon dictates from the executive branch or Congress, that it is now safe for them to hold regular court hearings and bring jurors in. Because the real problem with jurors is we put them in this big room. I mean, there's hundreds of them in this big room, and they get called out. You go to this courtroom and you go to that courtroom. And then they sit in a courtroom, sitting, not socially distancing as we know it now, or sitting in a jury box being asked questions. And then they're sent back to a jury room. When they're a juror, they're sent back to a jury room when they're excused for whatever reason there may be. And so all of those things just aren't going to work. Okay. So as a result of which, until it's clear that we can bring people together in gatherings of this kind, then I don't see jury trials taking place in the near future.
All right, that's great. That's very, very helpful, very informative. Thank you for your time. And I will be sure to hit you up for on different topics that people are asking about. So thank you much.
Always a pleasure.
All right.